Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. This is a continuing series of lectures for my Introduction to Criminal Justice class. Today we are going to tackle Chapter 12, which is Corrections in the Community. And, I was really sort of thinking about that title, Corrections in the Community. Now, if you agreed with my basis that one of the basic tenets of the criminal justice system is that we want to make people better exiting the criminal justice system as opposed to when they had entered the criminal justice system. And this is regardless of whether we're talking about victims or, in this specific case, offenders. We have to think about this, that these offenders are well on their way to, quote unquote, paying their debt to society. So what we're going to be talking about is this idea of corrections in the community, and really what this chapter hones in on is the idea of probation and the idea of parole, of either being sentenced to probation or serving a partial incarceration sentence and then exiting early with conditions. Both have conditions. The really easy way to know the difference between what probation is and what parole is: probation is a sentencing option. Judges can sentence a person to probation. Parole means you have been incarcerated, whether in jail or, more likely than not, in prison, and for some factor, we are going to shorten your sentence and let you out into the community with supervision. It's a lot of times offenders will sometimes think that probation and parole is a get out of jail free card, or people that aren't aware of these systems will sometimes think, oh, well, it's just a get out of jail free card. Not in the slightest. There's definitely monitoring, and that's what we're going to be talking about. So probation and parole is the most common alternative to incarceration. Community-based sanctions involving offender supervision. If there was any word I'd want you to underline there, or two words, it's offender supervision, which is why I don't consider it to be a get out of jail free card, because you are out of jail, but there are definitely conditions placed upon you. Advocates, or the people that are in favor of these incarceration alternatives, argue that it is less expensive and often more effective in rehabilitating offenders. Critics say that the shift from incarceration to these alternatives place offenders in the community too soon. And what this idea sort of means is that if incarceration, we don't avail these offenders of programs, if we don't modify these quote unquote antisocial or criminal behaviors, old patterns might reemerge. So probation, as I said, is a sentencing option for a judge. An offender is released into the community under supervision of a probation officer. In 2014, in our textbook, it stated that 56% of people that were sentenced to probation. Some demographic statistics: 75% of them were male, 54% of them were white. In the textbook gives you the full racial and sex breakdowns. Many offenders get incarceration sentences suspended by the court, meaning that instead of jail, instead of prison, they will serve probation for a specified time, 1 year, 5 years, something to that effect. So probation is a sentence in lieu of carceration. And probation standards differ state to state. depending on what sort of the pervading ideas of how to deal with offenders are. Are we a state that thinks we should, lock them up and throw away the key, or are we a state that thinks, well, you know what, let's try and fix or rehabilitate them? I'm skipping to slide number 7, the rationale behind probation. Support is based on the belief that maintaining the offender in the community, as opposed to this idea of staying in a jail or prison and getting this term institutionalized, has a greater rehabilitative effect on the offender. And if we have a greater rehabilitative effect on the offender, this theory sort of purports that we will lessen recidivism, the idea that people will continue to commit crime and continue to go through the cycle of the criminal justice system. Advocates for probation, these are people that are in favor of probation as opposed to incarceration, provides more individualized treatment and or counseling, allows offenders more opportunity to deal with their specific problems, whatever those problems are. And when we're talking problems, real general term, this can be mental health problems, this can be education problems, socioeconomic, employment, things of that nature. Avoids subjecting offenders to the negative effects of prison. And I already mentioned the idea of institutionalization, where you just get used to waking up at 5 o'clock in the morning, going to the chow hall, eating at 6 o'clock. You can only eat from, let's say, 0600 to 0615, 0620, whatever the case may be, something of that nature. No more likely to lead to recidivism than incarceration. And then the last one, less expensive than incarceration. And in our book, they give some statistics that the average amount to incarcerate an offender in the United States of America, so this is sort of an average of every state, about $27,000 per year. If you remember in the last lecture, we talked about New York, that's actually about $62,000 a year. And we're not even accounting for personnel costs. For probation, it's more along the lines of $3,000 per offender. So, I mean, that money-wise, it is a significant savings on society, on the taxpayer. However, the research available for this topic of this idea of advocating for probation is mixed. You can find studies that say that probation is a great program and it leads to great success with offenders, and you can find the exact opposite. So again, it's up to you which one sounds that it makes more sense, that it possesses more logic to you. Probation Administration, there is a federal level of probation, and obviously that jurisdiction is if someone was charged federally, went through some sort of federal criminal trial, and was sentenced by a federal judge. On the state level, the administration varies. In our book, it says that central statewide probation offices, sometimes probation and parole are combined, depending on how small the probation and parole system per state is. In a state like New York State, we have a big parole system, we have a big probation system, so they are separated. They are two mutually exclusive agencies. Administration at the county or local level. Now, in New York State, we only have a New York State of Parole. However, we have a New York City Department of Probation. So someone could be sentenced to probation for a misdemeanor. Someone could be sentenced for a probation for felony in New York City, and their probation officer will work in New York City. It won't be New York State Department of, probation. Depending on the jurisdiction, the caseloads per probation officer can vary. In states that have maybe very small probation programs, small parole programs, but we're talking more about probation right now. Maybe they have a caseload of 20. In a state like New York, it would definitely not be uncommon for a probation officer to carry 200 plus cases. Now, maybe that doesn't sound like a lot, but when we start talking about what probation officers do, and if you have a caseload of 200, balance that with the idea that probation officers do not work 24 hours a day, 7 days a week. They are workers just like everyone else. So normally full-time work is about 40 hours. Let's say they incorporate 10 to 20 hours of overtime per week. Let's say that was even possible. Still, do the math and sort of divide the caseload versus the amount of hours in a day, and we're going to get somewhere between 10 and 20 minutes per probation candidate, and that's not even accounting for travel time. Like if they were all lined up in a line waiting to walk into an office, and that's not all that probation officers do. Oftentimes probation officers make field visits. So the functions of a probation officer, it's not just, hey, how are you today? Did you go to work? Did you go to school? Did you get home at 9 o'clock at night? It's much more. So there is an initial intake or assessment of the probation candidate. Developing treatment programs. Again, we're talking about rehabilitation. So in order to rehabilitate, we need to make that person better. Well, how do we make that person better? Well, we need to add to their skill set, whatever that is. Mental health issues, yes, you're going to need mental health treatment. Education issues, you don't have a high school diploma, you decided you didn't even want to try while you were in while whatever in life. Well, now you have to enroll yourself in a GED program. Security assessment or risk classification, the idea of how serious was the offense that this person was sentenced for? What's their criminal history? What's their recidivism history? How often have they been through the criminal justice system? What's their age? What's their socioeconomic status? Are they currently drug users, or have they been drug users in the past? If they've been drug users, have they gone to rehab programs? Did they successfully complete those rehab programs, or did they abscond? How often do they go to these rehab? This could be done by the individual probation officer, and again, that would be in smaller probation departments, with smaller probation programs. In a state like New York, in a city like New York, these are probably distributed amongst various probation officers and or probation units consisting of probation officers. One of the ways a judge would determine eligibility. Again, we just talked about it. The nature and seriousness of the offense. Was a weapon used? And to what degree? Did the person only have a weapon on them, or did they actually utilize that weapon to commit the offense? Was the victim an active or a passive participant? The offender's prior record. Have they been in a probation system before, and were they successful? Meaning, did they complete the terms of their probation? Did they violate probation? How was that dealt with? Things of that nature. Prior incarceration, if they've been in parole, were they successful in parole? Did they violate parole sanctions? Things of that nature. A lot of times when we think about probation, when we think about the parole or these alternatives to incarceration, we tend to think that only those that have committed quote unquote nonviolent offenses will be offered this option. Not necessarily true. 20% of serious crimes of offenders that have committed serious crimes will be offered probation. The statistics that were given in the book, 2% murder offenders, that's a little nuts. 17% of people that have committed some type of sexual assault, and the book says rape, so that's really the highest level of a sexual assault And in New York State, I think we've discussed this already, regardless of what your gender identification or your sex identification is, it could either be charged with rape and or criminal sex act. They are actually the same exact offense. It's just a different sexual conduct. And 23%, 1 in 4, committing felonious assault. So in New York State, if you have been charged and convicted of assault in the second degree or assault in the first degree, you have a 1 in 4 chance of being offered probation. If you violate the terms of your probation, there is the chance that you will be violated and have to go back into jail and or prison and serve out the remainder of what your sentence was going to be. Some conditions of probation. Most states' federal courts have fairly uniform conditions of probation. These conditions it is a contract between the courts and the offender. Conditions imposed to fulfill two purposes: treatment and or rehabilitation. And although the book is dividing them, don't think that they have to be mutually exclusive. If a person gets treated for some type of issue, some type of symptom, what are we doing? We are, in effect, rehabilitating that person. Supervision to ensure law-abiding behavior. One of the provisions of probation is always going to be that you cannot commit another offense while on probation. That's almost intuitive. One of the interesting things is that, quote unquote, I got that get out of jail free card, so I'm out. However, there are conditions placed upon probation candidates that aren't placed on free citizens. For a free citizen, we have a Fourth Amendment protection against what? Unreasonable searches and seizures by agents of the government. However, if I've been sentenced to probation, one of the conditions of my probation is that I am giving up that right to the probation officer, not a police officer. Police officers must still establish probable cause. A probation officer, intrinsic in that contract between the courts and the offender, doesn't have to show probable cause. They can walk into someone's house. The probation officer can walk into a probation candidate's house, say, hey, what's up, buddy? I want to go check your bedroom. The probation officer can't say, oh, you have no probable cause here. It's a condition of that contract. It's that condition to take probation. The probation candidate always had the choice of saying, nah, I don't want probation. I'll stay in jail. Doesn't sound like most people would do that. So this is part of those conditions. Some other conditions: they must report to their probation officer. A lot of times the candidate will go to the probation officer's office, wherever that department may be, and they'll have some sort of conversation. How is the candidate doing? Is he or she gainfully employed? If he or she is a drug user, are they pursuing any sort of treatment options? If they have mental health issues, are they pursuing therapy? How often? Things of that nature. Restrictions of mobility. If I'm sentenced to probation in New York State without expressed written permission, and I better have a really good reason why I'm asking my probation officer for this permission, I cannot leave the state. Also, there are curfews that can be enforced. Let's say I'm on probation, I am gainfully employed. Well, it makes sense that if I'm gainfully employed, I have to leave my house. Let's say I work a 9 to 5. Whatever the case may be, maybe it takes me 30 minutes to get to work, so I leave my house 8 o'clock in the morning. I finish work at 5. Maybe I might have to have a curfew of, let's say a curfew's imposed of 8 o'clock, 9 o'clock. That sounds sort of reasonable, that if I'm not home by 9 o'clock, I have actually violated the terms of my probation agreement with the courts. Could also be subjected to random breathalyzer examinations or request to get a blood test to see if there's any sort of drug usage. Supervision of probation, supervision and treatment tasks are becoming increasingly complex. Human beings are complex creatures. We're complex systems. It just goes to sort of reason. Many agencies have turned over treatment of drug addicts to private treatment centers, and this makes sense because maybe a probation officer goes through their academy however long. I believe in New York City, their academy is 3 months. Now, in 3 months, they're going to have to learn what applicable laws apply to probation candidates, things of that nature, laws of arrest. They're going to have to learn their procedures. Well, what happens if I have to rearrest a probation candidate because he or she has violated the terms? All of this stuff. And there's probably some stuff about drug usage and what are the specific drugs, what do they look like, what are their effects. But you can't really learn how to substantively treat a drug addict in a week. So as drug usage increases, so do this idea that we need to treat those symptoms and give drug users the skills and concepts so that they won't go back to that old habit and continue using. Because usually what happens, a drug user starts using drugs again, they fall back into their old patterns start reemerging as criminal behavior, and then we have this cyclical criminal justice system yet again. Revocation or taking back probation. Probation is revoked if the offender commits another crime. So if a police officer arrests a person and they are on probation, even if the probation candidate, the person being arrested, never says it, it's going to come up on their fingerprints. If you remember, a while back we talked about one of the things in station house processing that police officers do when they have effected an arrest based on probable cause is that they will fingerprint, because fingerprints don't lie. Or they violate the conditions of probation. This is called a technical violation. If someone violates a technical violation, probation officers are given a wide latitude on how to deal with that. If maybe this was the quote unquote first strike, maybe the probation candidate does not go back to jail, does not go back to prison. Maybe the probation officer will say, I'm going to let it slide this time. If probation is revoked, what happens is a preliminary revocation hearing takes place. It's like a preliminary hearing at criminal trial, but there are some differences that I want you to sort of consider. One, hearsay evidence is allowed. Hearsay is third-party knowledge. Well, I didn't hear him say that, but she told me that he said that. That is hearsay. That would be allowed in this hearing. You cannot invoke your Fifth Amendment right to remain silent at a revocation hearing. If you try to, you will be placed back in jail. Then the revocation hearing takes place, and the standard of proof necessary to figure out whether a person has had some sort of technical violation and whether they're going either back into the probation system or back into incarceration is preponderance of the evidence. So think of these revocation hearings sort of like civil trials, that we have to have that 51%. We have to figure out which makes just a little bit more sense. With these revocation hearings, a couple of things. Due process is allowed. It is still a must. So evidence must be presented. The person on hearing is allowed to, quote unquote, confront and ask questions of witnesses. This is presided by an independent decision maker, so it does not have to be a judge. It is a quote unquote independent decision maker. There must be a written report, and the person who is the center of this hearing must be provided with that report. And then there will be a final hearing for the sentencing, whether we're going to put this person back into incarceration and or back into probation, and what new conditions there might be. There might be more stricter monitoring of movements, something like that. The effectiveness of probation, majority of probation cases are successful, about 62%, not too bad. Studies report that probation may not be significantly more effective than incarceration in preventing recidivism, in preventing people from continuing to engage in criminal behavior, to get arrested, to go through the quote-unquote system. One report that's brought up in the book states that 2/3, so we're talking about 66% of people that have successfully completed probation get arrested again. Out of that 2/3 that have been arrested, 1/3 of them actually get sentenced. Supervision with smaller caseloads are no more effective in reducing recidivism. So a probation officer that has 20 cases versus the probation officer that has 200 cases, although probably the one with 200 cases is way more overworked than the one with 20 cases, there's no more effectiveness in the probation officer with the smaller caseload if we're just talking strictly numbers. This idea of intermediate sanctions, increasingly attractive to policymakers. Why? It always usually comes down to money when we're talking about offenders. Sanctions are considered more severe than probation, but again, less expensive than long-term incarcerations. I'm now on slide number 16. Some intermediate sanctions. There is intensive probation supervision. There's more officer probationee or probation candidate contact. So maybe instead of seeing your candidate once a week, once every 2 weeks, maybe you're seeing them once every 2 days, maybe every day, something to that effect. Why might this be a good idea? Well, again, less prison overcrowding, public protections, and supposedly less recidivism. In theory, intensive probation supervision should encompass anywhere from 15 to 30 visits a month. So again, we're saying once a day or once every 2 days. The reality of this is that intensive probation supervision, maybe the probation officer, probation candidate contact is about 2 hours a month. So 2 hours in 30 days. I don't know how intense that sounds to you. This idea of house arrest and electronic monitoring. House arrest is basically what you think it is. You cannot leave your house, or you can only leave your house for specified legitimate reasons. A specified legitimate reason might be work, might be educational or vocational programs, could be religious, something to that effect. Electronic monitoring means that you wear something that tracks your movements. It's basically personal GPS. We all sort of have it, and we all sort of deal with it because everyone has a cell phone. Well, what does your cell phone have? Well, throw on your Waze. Your Waze knows where you are. So again, something to that effect. Day reporting centers. These are where these rehabilitation programs take place. They can be drug treatment programs, drug groups. These could be life skills programs. This could be anger management programs, could be vocational programs. Fines. Pay. What you're doing is one of your punishments is that you are going to pay the state back for whatever you committed. Forfeitures. You're going to give some of the stuff that you obtained via criminal means back to the state. Sometimes, for those of you that have ever gone to, let's say, like a vehicle auction, you'll see a lot of really nice cars. A lot of times what happens is that one of the intermediate sanctions of a person that was sentenced was that they had to forfeit anything that they purchased via a criminal enterprise. So let's say I bought a $100,000 Escalade because I was a drug dealer. Well, guess what? I'm going to lose that Escalade, and maybe someone is lucky enough to go to an auction, see it, and get it for about 30 grand. Restitution, you're paying the victim. So think about this. Fines, who are we paying? We're paying the state, we're paying the city. Restitution goes directly to the victim. This could cover medical issues, therapeutic and counseling issues, lost wages, prescriptions pursuant to the medical or mental health issues, property damage, crime scene cleanup, things of that nature. Community service, paying the community. Maybe I'm working for a charitable organization. Maybe I am a media-worthy person, so I do some PSAs, some public service announcements. Hey kids, don't do drugs. If you do drugs, you're going to land in jail. That was my problem, and now I'm fixed. Something to that effect. Maybe assisting the elderly. Maybe some sort of public works, public maintenance, cleaning up parks, cleaning up highways, things of that nature. I am skipping around. I am now on slide number 25. This idea of restorative justice. Now, if you remember in probably one of my very first lessons, when I talked about the idea of what is the difference between criminal law and civil law, or criminal offenses and civil offenses. Well, a criminal offense is an offense against society. Civil offenses are offenses against a victim. I get into a vehicle accident, I have damage to my car. I want the person who caused me to get into this accident to pay for the damages. He or she says no, we go to civil court. Judge listens, preponderance of the evidence, he or she listens to both sides, which side makes more sense, just by a little bit, and then we'll figure out that. Well, we talked about criminal law. Well, restorative justice takes the focus off the idea of this being an offense against society, and an offense in turn thinking about this is an offense against an individual. So it focuses on community, aims to change the way people think about crimes. And just like I said, crime viewed as a violation of community and the relationships between the offender and the community. Not a wrong against society, but against individuals and or victims. Government should only take a limited role, victims placed at the center of the criminal justice process. Forms of restorative justice. Victim-offender mediation. What this is that you have a victim in the room, you have the person that committed the offense against the victim, some sort of independent arbiter, and they discuss what happened, why did it happen, why the offender is sorry, how did this impact the victim, things of that nature. Family group conferencing, discussions of the consequences of the offender's actions. A circle sentencing. Circle sentencing means everyone that was sort of involved in the offense will be present at the table. So we have the offender, we might have the victim, and if we don't have the victim, we have some sort of member of the community that represents the victim's interests. Social service programs, the police officer and or group of police officers that affected the arrest, that were involved in the incident. Reparative probation, a board of local citizens develop appropriate sentencing models. Criticisms of restorative justice. Does not offer any realistic set of policies for control of serious crime. Does not offer ways to reduce high recidivism rates. This was by Sharon Leverant. Crawford and Clear, advocates assume community consensus without defining what the boundaries of community are. What is a community? Who represents the community? Why do they represent the community? These are questions that you should always be asking. When someone says, well, I represent the community, okay, you represent the community. What do you mean by the community? Why do you represent the community? And what makes you the spokesman of the community? Many communities are too heterogeneous, meaning too similar to promote a consensus. Um, Now let's just get into parole. Probation is what? A sentencing option, so you don't go to jail and then get probation. Parole works differently. You have served a part of your sentence, and depending on what state you're in and depending on your behavior while you were incarcerated, could be one third, could be one half, could be two thirds, depends state by state. States are allowed to make those decisions. Parole is a conditional release of an offender from a correctional institution after the individual serves a portion of his or her sentence. The offender remains under community supervision and in legal custody of the state. If the offender violates conditions of his or her parole, they may be reincarcerated. So that's why a lot of people sometimes use the terms probation and parole interchangeably. However, they are not interchangeable. They are two very different things. I am skipping to slide number 31, unconditional release. This is release without supervision of inmates who have served their maximum sentence. Okay, so if you have served your complete sentence, you're not going on parole. You didn't do probation. You were incarcerated. Let's say you were sentenced to 2 years in prison. You serve your 2 years, your 24 months. 24 months and a day, you get intaked out. And that's it. You are now a free member of society because you have, quote unquote, paid your debt to society. However, there are two forms of unconditional release that are sort of interesting that we should talk about. This idea of commutation and clemency. Commutation is an executive order. So if think about this, executive order, who are we talking about? Well, we're talking about executive branches of government. So could be on the federal level, the president. If we're talking state levels, we're probably talking governors. Reducing a sentence for release. Clemency is otherwise known as a pardon, where you are exempting the offense. So commutation is a reduction, clemency is an exemption. Halfway houses, also called community correction centers and or reentry centers. What is a halfway house? Well, we're transitioning this person that has served a sentence, transitioning them from this institutionalization sort of mindset into the mindset of a free citizen. Provides secure housing of inmates while giving them the opportunity to take controlled steps back into the community. Because a lot, you lock them up and throw away the key, but eventually that person has paid their debt to society. So now we picked that key up and we opened up the gate. Now what happens? Well, we want them to transition. Again, the criminal justice system is based on this concept that we want people exiting better than when they entered. Well, we have to provide them with something in order for them to be better. May attend school, work, participate in job training, receive counseling. I've talked about some of my personal experiences, and prior to me being a police officer, I was a substance abuse counselor on Rikers Island in the detention center. And one of the things that I did was I would do group counseling sessions, things that maybe we take for granted. How do you interview for a job? I am assuming for most of you that are listening to this lecture right now, you've probably interviewed for jobs, you've probably learned some certain social norms. You walk into an interview. A lot of these, especially for me, I worked in a men's jail, so for a lot of my men, they didn't know that when you meet a person, the first thing that you should do is shake hands and say, "Hello, my name is Keith. What's your name?" That's a life skill that has to be taught. Most of us were taught this at an early age. For whatever reason, some of my groups, they didn't even know this. So life skills to that effect. Here's another life skill. When you have a conversation, you make eye contact, unless there is some sort of cultural norm where you're viewing a person as someone of a high authority or something to that effect. But if we're talking natural, casual conversation between quote unquote equals, you make eye contact. That might be something that someone didn't know. That's a life skill. Violations of rules may lead to a return to prison if they are in this halfway house. So again, curfews, no drug or alcohol intake, things of that nature. If you say you're going to work, well, I can check. I can check. I can call up your employer. Did he or she go to work today? Were they late? How late were they? And now this person would have to account for what happened. It could be something that, there was a 30-minute train delay, or it could be that he or she went to the old neighborhood to pursue old bad habits. Temporary release. Inmates are released from prison on a temporary basis. Types of temporary release: furloughs, work releases, and educational releases. A furlough means that you're leaving for a specified time for a specified reason. This could be anywhere from a week to maybe, anywhere from 1 day to 1 week. Think of holidays. Maybe, I am incarcerated, but I have a family. I have a wife. I have 3 small children. Coming on Christmas, maybe I get furloughed out for 3 days so I can spend Christmas Eve, Christmas Day, and the day after Christmas with my family. Maybe there was a death in my family. Maybe that might grant me a furlough. A work release means that I'm allowed to go to work, but I have to come back to my jail or my prison. Or educational release. I go to school and then I come back. These options are usually provided for minimum security prisons. There are different types of prisons, and for those of you that are going to continue your criminal justice studies, when you start talking strictly corrections, you're going to learn that there are minimum, medium, max, and supermax security prisons. Parole boards reviews inmates who are eligible for conditional release from prison. So the person that might be up for parole will be judged by a parole board. Now, this parole board can be it's really state by state and defined how big that they're going to be. About 1 in 4 people that are up for parole actually do get it, which means 3 are denied. Boards make discretionary decisions about prisoners' release based upon criminal background. Prison rule violations. Are they violating the rules? Are they violent in prison? Are they bringing contraband in? Has contraband been found in their cell? Are they participating in treatments? Are they participating in groups? Statements by families, by lawyers, friends, etc. Parole decision making. Parole hearings scheduled when inmates become eligible for parole. The board reviews the institutional file, the things that we just pointed out. Will question the inmate. Why do you think you deserve parole? And then the offender, the one that's up for parole, has to pretty much acknowledge what they did, why they think it's wrong, why they feel that they won't do it in the future, what they got out of prison, what they got out of their treatment options, things of that nature. Prosecutor, defense attorney, friends, relatives, and of the inmate and victim may present oral or written statements pro-parole or anti-parole. One of the last concepts that we're going to talk about is really sort of a triggering kind of concept. The release of sex offenders, so people that have been sentenced, that have been convicted and sentenced to some type of sexual offense, some type of sexual assault. Now, this can run the gamut. This can run the gamut between touching sexual areas to rape and criminal sexual act, where we're talking about either oral, vaginal, or anal sexual conduct. It's a controversial issue, even when the full sentence has been served. So a person gets sentenced for whatever this violation is, some type of sexual assault. He or she serves out their full sentence. In theory, They have paid their debt to society. They did the crime, they did their time. However, how do we feel about that? I remember I taught a corrections class last semester, and I threw out the question, who wants to live next to a registered sex offender? And not one person raised their hand. And then I asked, well, who would want to live next to a person that was convicted of murder? And it was an interesting sort of subject that more people would rather live next to a person that's committed murder than has committed sexual assault. Now, I'm not making a value judgment either way. That's on you to think about. I know where I would probably fall on this, but it's an interesting concept, and it's the concept that, we're trying to deal with it logically. However, there is a lot of emotional trigger to this. Megan's Law requires registration and community notification by sex offenders when they move into community. In New York State, there are 3 levels of sex offender: level 1, level 2, level 3. Level 1 being the lowest offense, level 3 obviously being the highest offense. Even if registered, offenders may recidivate, meaning even if they've did the crime and served their time, even if they've registered with their local police department, there is always the chance that they might go back to old habits. And again, it's up to you to decide how you feel about this, how you intuit this. Conditions of parole, similar to the conditions of probation. I'm not going to really go back to them. Most offenders are granted parole are eventually discharged from supervision, meaning that they successfully complete their parole. Just like in probation, parole, sort of the same thing. Offenders who violate terms are normally returned back to prison. And again, parole is a contract between the courts, between the parole board and the offender. So again, like those Fourth Amendment protections, where a police officer, in order, if they want to search a residence, what do they need? Well, we know they need a search. They need a search warrant barring some sort of exigent circumstance. Parole officers do not. They can knock on the door. They must be let in. That's a condition of parole. And they can say, well, you know what? We're going to search the house. And they say, oh, you can't do that. Yes, they can. Yes, they can. Parolees are at a disadvantage as they begin parole. Few resources, limited skills, felony conviction stigma. Now, that's an interesting sort of topic. All right, now you did jail. Be a functioning member of society. One of the things that you sort of have to consider is, if you were an employer, would you want to know a person's criminal history? You probably would. Now, if there is a criminal history and let's say it's a violent offense, do you have the right to reserve your judgment and not hire this person based on their criminal behavior in the past? I'm not going to give you the answer to that. It's a question that I want you guys to start considering. So if there is this stigma of this person being convicted of a felony, again, there's less access to jobs. And you can read the rest. I think I'm about done with this. So I wish you all the best. Everyone have a great day. I hope you are all well, happy, and healthy. Take care.